EasyGroup Limited and Easy Life Services Limited and others.
Yes, Mr. Edinburgh.
My lord, my lady, I appear along with my learned junior, Miss Wickenden, for EasyGroup, the
Yes.
appellant, who are the claimants below, and my learned friend, Mr. Akins, appears for ELA, who are the defendants of the respondents before you. Pursuant to the Lady Chief Justice's Baroness Carr's announcement on the 8th of November 2023, subject to your lordships and my lady, my learned junior will address you in reply, if that's
Yes,
okay.
that's fine.
And also thank you for allowing her to have an extra table for her chair and what
No
have
problem.
you. Thank you. My lord and my lady, you should have 3 bundles: the core bundle, the supplementary bundle, and the authorities bundle.
Yes, I've got 4 actually, but to the authorities are in 2 bundles. But
Oh,
it's the
right, yes.
same thing.
Yes. I collated them together. You should have received, well, there will be skeleton arguments that are in the bundles
Yes,
themselves.
we've read them and we've read the judge's judgment.
I'm most grateful for
So
that
we know,
indication.
well, we know as a matter of form what the case is about. But what is the point of the appeal?
My lord, there's 2 points really. With respect to ground 1, it's a fundamental issue whether or not passing off occurred, and that has ramifications both for this case but also for wider litigation matters with respect to this claim.
Because your damages will be the same, won't they? You're not going to get anything more, are you, out of
It's
the defendants?
certainly arguable that they would be coterminous, yes. Whether they strictly are is a separate issue, but in practice, it would be difficult for me to say there would be a large difference. And with respect to the declaration...
Well, that I understand. That's a separate point.
Fine.
So, no, it's really your first ground that
My lord.
I was puzzling over.
My lord, the way in which we were going to do it, subject to your lordship's and my lady's view, is that I was going to open on grounds 1 and 2. My learned friend was going to respond to that, and also raise his respondent's notice.
Fine.
And then we're going to have a reply with my learned junior.
Yes.
My learned friend has said that if anything is new raised by my learned junior, he would like to then address you, so to speak, in a reply on the respondent's notice, again subject to your views, my lord and my lady. Is there anything else? You should, have received one other thing. When the skeleton argument was transformed from a Word document to a PDF, some of the formatting went wrong.
Is this sheet you've got on the bench?
Otherwise, you should have received everything in hard and soft copy.
Yes.
My lords, in which case, my lord and my lady, in which case, I'll deal with the background to the matter, if I may, and then go on to my grounds 1 and 2. So the background to the case is that this was a trademark and passing off trial before Sir Edward Mann. It was dealing with EasyGroup's trademarks, in essence, against a series of signs that incorporated the words Easy Live Auction. If I may take you to the core bundle, tab 13, page 257. And it's the paragraph below the second punch hole. You can see that the allegation relates to the sign Easy Live Auction, the sign, and then it says various stylized versions of the sign have been used by the defendants to provide services at the website. And if you then go to the particulars of claim...
Just pausing there, it may be helpful to pick up at this point what's in the first paragraph, which refers to the claimant, that is to say EasyGroup Limited, owning, operating, licensing brands of numerous businesses, trading under the names comprising the word Easy and then so on and so forth. And then it says through substantial trade in the businesses operated under the Easy family of brands, the claimant has built up goodwill and reputation in the UK and the EU. And this is something we're going to need to come back to in a little more detail in due course. But we see there the claim is being put on the basis that it is EasyGroup that is the owner of the goodwill. Yes.
My lord. Yes.
You're going to have to make that link for us because the judge's finding was about goodwill of EasyJet.
Yes, my lord. There's a licensing arrangement between EasyGroup and EasyJet.
Yeah, we sort of picked that up from my lord's judgment in W3, to which the judge refers.
Yes, my lord.
His
That's
judgment, but we don't have the document, and you don't seem to refer to it in your skeleton argument.
no, because I didn't know that you were going to directly ask me about that particular point.
Right. It's common ground, is it, that goodwill generated by EasyJet belongs to EasyGroup?
Yes, that must be so because there's a licensing relationship whereby EasyGroup is in essence the master, and EasyJet pays EasyGroup for the use of EasyJet. Does that answer my lordship's?
Not entirely, but
Not
I think I've got the gist from my lord's judgment in W3,
Yes.
where he sets out a number of the terms of the
Yes,
licensing agreement.
my lord.
But it's a missing link.
My lord, yes. I'm sorry, I didn't realise that we were going to that particular missing link. My lords, if you then actually turn the page to the next tab, which is tab 14, and if you go to paragraph 43, which may be found on page 292, this is where you see the definition of various allegedly infringing signs in paragraphs 43.1,
Yeah.
point 2, point 3, and point 4. And they are appropriately called signs 1, sign 2A, and sign 3, and then sign 4. Sign 2 actually had two versions, with or without a little R and a circle on the top right-hand corner, and they're distinguished by being called sign 2 capital A and 2 capital B. It's just so you know precisely to what we are referring. And so that's how we say that we put those four signs in issue. Then if you look at the way in which the defendants responded to that, you'll find that at the amended defence and counterclaim paragraph 28, which is behind tab 15 on page 309. And what you can see is that they're dealing with those four signs. Those four signs were introduced at different periods historically, and so therefore they're addressing there the allegation of when those signs came into use.
Sorry, wait a minute.
Sorry, my lord.
You said 309.
309, yes, and it's paragraph 28.
Right, because the response to paragraph 43 is actually in paragraph 47 on the previous page.
Oh, sorry. Yes, my lord, I'm terribly sorry. Sorry, I was jumping ahead in the sense that this was the bit that dealt with the time frame when the various signs were used. And the reason why that is relevant is that you can see that what was in issue between the parties were these four signs and when they became used. And paragraph 28 of the defence deals with the timing of the introduction of the various signs.
Right.
Now, in brief, the claimants were successful upon the trademark allegation based upon section 10(3) of the Trademarks Act on signs 2A, 2B, and 3. And that was successful predicated upon those three signs taking unfair advantage of the reputation that resided in the mark EasyJet. It was found that sign 4 did not infringe. Sign 4 was introduced in March 2019, which was after the letter before action, which was served on the 30th of October 2018. And sign 1 in essence fell away. There was a finding that there was no infringement, but it was of such historical antiquity that there was never going to be any issue with respect to damages because it was beyond the limitation point. But there was a finding of no infringement with respect to sign 1 as well. There were other issues in play between the parties. Very briefly, there were various attacks upon the use, the genuine use or otherwise, of certain of EasyGroup's trademarks. And broadly, they were more or less successful across the range. But the details of that don't matter. It's just there was an attack, and that attack was successful in part. There was also an attack by the claimants on the validity of the defendant's trademark, which had then become registered. Originally, it was only an application, but it had become registered, and that attack failed. And also, what failed was that there was no passing off. That's the subject of ground 1, and because there was no damage. And what also failed was that there was no trademark infringement pursuant to section 10(2) of the Trademarks Act, which was because there did not exist a likelihood of confusion with respect to trade origin vis-a-vis the relevant marks that were invoked and the relevant allegedly infringing signs. But what you'll notice from all of that was that there was no declaration of non-infringement sought by the defendant. I'll come back to that more when I deal with ground 2, but you can see that from the pleadings in any event. And so with that by way of general introduction, I'll move to my first ground unless there's any particular points that your lordship and my lady would like to deal with now. My learned junior has passed up a note to me which addresses, I think, my Lord Lewison's point about the EasyJet, so I probably ought to deal with that now. The note reads that goodwill in EasyJet was admitted and that it was owned by the claimant, and that's recorded in the judgment of paragraph 226.
226.
Yes, which is in the core bundle tab 8, page 172.
Is about the goodwill of EasyJet.
Yeah.
Well, what I was asking you about was where the judge finds that the goodwill generated by EasyJet belongs to EasyGroup.
Yes, and that's the first part of it, in the sense that the goodwill is admitted in EasyJet.
Oh, yes.
And then if we move to the to the amended defence, which is where we were, tab 15.
Yeah.
And it's page 302 at paragraph 9A. And that admits the protectable goodwill.
Right. Yes, but
And then
it also answers my lord's question, which is it admits that the claimant was the owner.
yes. Sorry, I was
So
thinking within-
so it wasn't an issue,
no.
is the short point.
Yeah.
Right.
It also carries on at just for your notes, my lord, it also carries on at paragraph 10 of the amended defence. So, moving on to ground 1, I need to put my appeal in context. I need to lay a few foundation stones, I'm afraid. So the first point is, of course, that passing off is a common law tort, of which there are 3 elements. There's no dispute about this, that you need a protectable goodwill, you need an operative misrepresentation, and you need damage. And being a common law tort, damage is an essential component in order to complete the tort, to make it actionable. The learned judge found that there was a protectable goodwill. And he also found that there was a misrepresentation. I'm going to flesh that out in a bit in a moment. But he held that the tort of passing off that allegation failed because there was no damage. So we fell on the third hurdle. We say that the reason he held against us on damage was that he was wrong as a matter of law. It wasn't a multifactorial analysis that he conducted and then we say he got wrong. Rather, we say that he got it wrong as a matter of law because in the face of the finding of fact under section 10.3, which is the unfair advantage, that those facts relating to the unfair advantage support an accepted head of damage in passing off. And what he failed to do was realise that that was a perfectly transferable set of facts so as to found properly a head of damage in passing off and therefore to complete the tort. And so his error was failing to realise that you could take one set of facts and apply them equally to the passing off situation. And in order to make good my point, I need to show you that the issue of misrepresentation, that you have various types of misrepresentation, and depending upon the particular wrongful act, you lead to different sorts of heads of damage. And in essence, he failed to appreciate that with respect to this particular wrongful act, you can properly lead to a head of damage which is accepted under passing off. Now, I need to backtrack, so to speak, and put the tort of passing off a little bit in its historical context in order to make good how it's been developed. And historically, passing off used to be quite simply that a trader wrongfully represented that its goods or services were those of the claimant. And so it was very much a wrongful misrepresentation as to trade origin. And I can show you that, illustrating that with an old case, which is in the bundle, which is the case of Claudius Ash. In the authorities bundle, it's behind tab 1. And in particular, it's on page 13 of the authorities bundle, which is page 475 of the report. And it's the paragraph just below the second punch hole, starting at line 35. As regards the charge of passing off, put it as you will, it must be established that defendants' goods were calculated to mislead purchasers into the belief that they were the plaintiff's goods. That's a classic statement of the old type or classical type of passing off. But the law on passing off has evolved like many common law torts. And so if I might then take you to the Irving case, which is behind tab 4 of the authorities bundle, and starting at page 106. And in the holding, which is between letters D and E, if I might read this out, held, giving judgment for the claimants, that the first claimant had a property right in his goodwill, which could be protected by the modern law of passing off from unlicensed appropriation consisting of a false claim or suggestion of endorsement of a third party's goods or services. That the purpose of a passing off action was to vindicate the claimant's exclusive right to his goodwill and to protect it against damage, even if it was not immediate. That it was therefore not necessary to show that the claimant and the defendant shared a common field of activity or that sales of products or services would be diminished, although the claimant would have to demonstrate a misrepresentation, since it was the misrepresentation which enabled the defendant to make use or take advantage of the claimant's reputation. That for a passing off action to succeed in a false endorsement case, the claimant would need to prove that at the time of the acts complained of, he had a significant reputation or goodwill, and that the action of the defendant gave rise to the false message, which would be understood by a not insignificant section of his market, that his goods had been endorsed, recommended, or approved of or by the claimant. So we say that's a fairly accurate summary of what was held within the case. I'll take you to that in a moment. But the point being is that the tort of passing off has moved on from the classical form of misrepresenting one's goods or services to a wider form of passing off, where the misrepresentation, so the wrongful act, can also be a misrepresentation as to endorsement, as to approval, or something like that, some sort of connection in the course of business. And I can make that good if you go to paragraph 38, which may be found on page 118 of the authorities bundle. In my view, these cases, this is where the judge, this was Mr. Justice Laddie sitting at first instance, had reviewed the historical cases and showing how the law had developed. In my view, these cases illustrate that the law of passing off is now of greater width than as applied by Wynne Harrijay in the old case of McClock. If someone acquires a valuable reputation or goodwill, the law of passing off will protect it from unlicensed use by other parties. Such use will frequently be damaging in the direct sense that it will involve selling inferior goods or services under the guise that they are from the claimant, but the action is not restricted to protecting against that sort of damage. The law will vindicate the claimant's exclusive right to the reputation or goodwill. So that is, in essence, the section in the judgment upon which the head note is predicated. And we in particular rely upon the fact that it shows that the tort of passing off has expanded in nature. This may also be shown in the Fenty case, which is the Rihanna case. And this is behind tab 7 of the authorities bundle. And I'd like to pick it up, if I may, at paragraph 23, which is on page 195. Finally, the judge dealt with damage. He considered that if, as he believed to be the case, a substantial number of consumers were likely to be deceived into buying the t-shirt because of a false belief that it had been authorized by Rihanna, then that would obviously damage her goodwill. It would result in a loss of sales to her merchandising business, but also represent a loss of control over her reputation in the fashion sphere. It was, he thought, for her to choose which garments she endorsed. In all the circumstances, Top Hat's sale of the t-shirt without her approval amounted to passing off. Now, I realise that that in some senses has jumped ahead to the damage point, but it shows the link that I'm trying to form between the particular wrongful type of act, the particular wrongful misrepresentation, and the way in which certain damages may flow, certain heads of damages may flow from that. Excuse me. This also is developed further in paragraphs 37 to 38 of that case, at pages 198. It's not necessary for the purpose of these proceedings to attempt to define all the circumstances in which the law of passing off may be invoked to prevent the unauthorized use of a name or likeness of a famous, real or fictitious person. For here, Rihanna contended that she had a reputation and goodwill in connection with her business activities, and further, that the use of her image on the t-shirt amounted to a misrepresentation that was likely to deceive members of the public into believing that it was approved of or authorized by her, and so in short, that she was happy to be associated with it and had endorsed it. Put another way, it was her case that the misrepresentation that she was associated with the t-shirt made it more attractive, and so played a material part in the decision of the public to buy it. And then carrying on over the page of 38, in my judgment, this allegation did disclose a sustainable case in passing off. In substance, Rihanna alleged that she had suffered damage to the goodwill in her business as a result of the misrepresentation implied in all the circumstances that she had endorsed the T-shirt. So this is moving away from the classical form into the wider form of passing off, which you say is particularly relevant here, that if the wrongful act is a misrepresentation as to endorsement, then you can still end up with a head of damage that satisfies the damage requirement in the tort of passing off. Now, I need to contrast this with a situation where there might be some sort of wrongful act, but it doesn't actually amount to passing off. And we can find this in the Moroccan oil case, which is in the next tab of the authorities bundle. Very briefly, what happened here is that in Moroccan oil, it was only a passing off case. There was no trademark case at all. And so therefore, it's, so to speak, far more relevant to the present case because we're only now looking at the passing off aspect of the case that went below. Now, you can actually see the products on the very last page of the report, which is on 228. And my reproduction is in black and white. So you don't get the full force of the fact that the colours were really quite similar. So I acted for the successful defendant here. So when I say quite similar and we won, you can read what you like into how similar they were or otherwise. But I can pick it up at paragraph 32 of this case. And that's on page 220 of the authorities bundle. Now, the way in which this case is relevant is that what I'm about to show you talks about the link. Now, that word is the word that is commonly used within the consideration of a section 10.3 infringement and is necessary to establish 10.3 infringement. And so that's how it all dovetails into this case. So on 32, one of the issues in this case was the effect on the relevant public of the similarities in get-up and name between MIL, that's Moroccan Israel Limited, and Audi's product. Ms. Michaels accepted that establishing a link in the mind of the public within the meaning given to that term as an element of trademark infringement pursuant to Article 5.2 of the Trademark Directive. Just for your parenthetical note, Article 5.2 of the Trademark Directive copies directly over to Section 10.3 of the Trademarks Act. Anyway, that link would not be sufficient for passing off. No misrepresentation would be established if it were shown that the similarities did no more than cause Audi's miracle oil to bring MIL's Moroccan oil to mind. A recognition on the part of the relevant public that the name and or packaging of the former looks similar, even strikingly similar, to the name and or packaging of the latter would not by itself translate into an actionable misrepresentation on the part of Audi. And then moving on to paragraph 33, this is where we get a discussion of the living dangerously concept.
Well, I dealt with this a little more fully in the subsequent decision in Glaxo.
My lord, yes.
Maybe it's better to come back to that in that context.
Right, I was...
Something here that you want particularly.
Well, I was going to go to that in a moment, my lord. So,
fine. I'm sorry. Take your own course.
No, my lord. Anyway, the point here is, as my lord, Justice Arnold has pointed out, is that this idea of living dangerously is, in some sense, is a two-edged sword because it can work both for and against a potential defendant in the matter. And what I was going to do is to direct you to 33 through to 35, but I'll pick this up actually in my Lord Justice Arnold's case, in the Glaxo case next. But just before we leave Moroccan oil, can I just take you to the end, which is paragraph 62. And this is the damage point, which was, if I had lost on the misrepresentation point, which was a false association point, then it was said that I conceded sensibly that if MIL established a misrepresentation of any type relied on, the judge would be entitled to refer that MIL had suffered damage, and I need therefore to say no more about damage. So the point being there is that with respect to the relevant misrep, in that case, I realise this is a concession, I
Just a
conceded...
previous consistent statement, Mr. Eagle.
I'm not quite sure I'm standing on trial, but yes, my lord. So yes, it's basically the point. But it's more than just a previous consistent statement. It's one that's been accepted by the judge. So it's to that point that I raise it. If we then go to the Glaxo case to which my Lord Justice Arnold has just referred, you'll find that behind tab 11. This is the Glaxo and Sandoz case. There are two Glaxo cases here, and so to try and avoid some ambiguity, I was going to refer to it as the Sandoz case. And jumping straight into the point is at paragraph 188 on page 334. Lord Justice Kitchen was careful in this passage, that's the passage quoted previously in the previous paragraph 187, not to say that a conscious decision on the part of the defendant to live dangerously could never support a claim for passing off. Counsel for Glaxo submitted that the relevance of such a state of mind was that it showed that the defendant, a person who knew the relevant market, was aware of the risk of deception and proceeded recklessly in the sense of not taking care to avoid that material risk. Counsel for the defendant submitted that if the defendant showed that he did not want his customers to be deceived, that was probative of a lack of a likelihood of deception. In my judgment, this is precisely why Lord Justice Kitchen said that it all depended on the facts of the case. If it is proved that the defendant was aware of the risk of deception and proceeded recklessly, then that is capable of supporting the conclusion that deception was likely, even if the defendant did not intend to deceive. If, however, what is proved is that the defendant was aware of that risk, but thought that he had done sufficient to avoid it materialising, then that is not supportive of the conclusion that deception was likely, but rather the reverse. And so, unpacking that a little bit, what one has here is that if you have a defendant that is knowledgeable of the market, and if their intention, their subjective intention, is to not misappropriate the reputation, the goodwill of the claimant, then that subjective intention can be used to find that there was no operative misrepresentation and no damage. And that's what occurred in Moroccan oil. So in Moroccan oil, you had two products that were quite similar in the get-up and what have you. But the evidence from Audi, the defendant, was that, yes, it knew the market. It had one of those picture boards of the various products up, and the claimant's product was there. That was all established at trial. In fact, I think it was even admitted beforehand. But the point being is, it knew the market, and it knew what it was doing, and it was trying to avoid any misrepresentation. And that evidence was all fairly clear. And the judge said, well, in that particular case, they knew the market, they knew what the risks were, so in some senses they were living dangerously, but they were really trying not to cross the line.
Why should that matter? If I've never heard of EasyJet and I set up Easy Legal Services, why does it matter whether I intend to deceive or not, if in fact people are deceived?
Well, the point being, my lord, is it's a secondary factor. So if you say that, I mean, objectively, there's no doubt there's going to be deception, then that's pretty much the long and the short of it, and you'll find deception. But there are many cases in passing off where you allege the intention because you want to add some evidence one way or t'other. From a defendant's point of view, it might be, as was the case in Moroccan oil, that the allegedly tortious product was really quite similar to the claimant's product. And there's no doubt that Audi knows the market. And so it produced evidence at trial that it was very much trying not to deceive and misrepresent its product for somebody else's product. And the judge found that that was the case. But the flip side is that if you find that there is an intention to misappropriate the goodwill, then that can be taken into account. And so it goes to the point, a number of points, in that first, there are different sorts of wrongful acts. So the misrepresentation might be that the defendant's product is the same as the claimant, but it might be a misrepresentation. The wrongful act is that you're merely saying that there's a business relationship, some sort of commercial connection, endorsement or something like that. And if there's an intention on the part of the defendant to live dangerously, but knowing the market, it really does not wish to wrongfully misappropriate the goodwill, then that can be used as evidence in the defendant's favour. But if there is evidence that the defendant was intending to misappropriate the goodwill, then that's evidence that goes in the favour of the claimant to establish the tort of passing off. And so that shows that there can be a number of different ways in which the evidence of intention can be used. But you still look at it. It's not that if the intention is only to commit a fraudulent offence at a very high level, can it be taken into account? It can be taken into account with in these other cases where the wrongful intention is to misappropriate the goodwill.
What's the theoretical justification for that? I mean, passing off is about deceiving the public, the consumers of the goods or services in question,
Yes.
who won't have the faintest idea what's going on in the mind of the person who is alleged to
My
be
lord,
passing off.
yes,
So,
accept that.
how does that person's intention affect whether or not the tort has been committed?
The point being is it's an evidential.
But what does it show?
Stand. I'm sorry, my lord.
But what does it show in the mind of the consumer of the goods or services in question?
My lord, you're coming at it from the objective sense, which is absolutely
Yes.
right, because it's whether or not something is operated upon the mind of the consumer such that they are misled or deceived, to use the old language. But sometimes, in fact, more often than not, these cases are very much in the balance. And so therefore, the court looks at the subjective intention, which of course the objective person in the street doesn't know about. But they will say, for example, if somebody's striving to pass off and they know the market, then we as a court will be hesitant to say that they failed to do the wrongful
Well,
thing.
I understand the pragmatism. I'm not quite so sure of the principle.
Well, my lord, that's pretty much as far as the principle drives you.
Is it
Sorry.
no more than the business, because they know the market? In effect, that may be some evidence of the market, and therefore evidence of the position of the consumer.
My lady, exactly so. It's a sort of, it is slightly circular in that sense. But if you have a person that knows the market, then it's thought that they know how the mind of the public operates.
Oh, I see.
But my lord is right. Well, both my lord and my lady are right, but from different ends of the telescope, if you see what I mean.
Anyway, there it is in the
Yes.
authorities,
Yes.
and that seems to be the law.
Yes. My lord, might I just take, my lords and my lady, might I just quickly take you to one more authority before I dive into the evidence, and this is behind tab 6. This is the Fine and Country case. And it's paragraph 57, which starts at page 166. Picking it up at the third sentence, which is the penultimate line. As Mr. Hicks rightly submits, there need be no common field of activity between the claimant and defendant in a passing off action, but in any event, the fields of activity are sufficiently close in that case. If the brand is damaged, GPEA's ability to attract license fees will also be damaged. Its ability to attract license fees is itself goodwill. It then discusses a section in Wadlow, which is discussing the relationship of a franchisor to a franchisee. And in essence, the franchisor's business is in the business of licensing to the franchisee. And so that supports that proposition. And then on page 171, starting at paragraph 76, running through to 78, this is the passage that talks about, in essence, future damage as opposed to damage that has already crystallized. And without reading it out in summary, it's that, in essence, any consideration about the future must be to a greater or lesser extent speculation, because of course it's can't be proved, because you can only prove historical fact. But you can still, in essence, make a proper finding about what may, in the court's judgment, happen in the future. So that was by way of laying the groundwork from the case law. And then might I try and dovetail that into the findings that the judge made in this case. And for that purpose, if we go to the core bundle, please, and if we go to the judgment, which may be found behind tab 8, it starts at page 95, but I'm only going to take you to a few paragraphs. The first of which is paragraph 216, which is on page 170 of the core bundle. Now, obviously, we're starting here with the trademark case, and in particular the section 10.3 case, the unfair advantage, because these are the findings that I wish to cross-fertilise into the passing off. So at 216, the judge is talking about the section 10.3 unfair advantage point. I consider this requirement to be fulfilled for reasons closely allied to the last point made above. Mr. Burnside, now he was the third defendant, and he was one of the directors of the first defendant, but he was the person who was responsible for the creation of the signs. And so that's why he was being asked these various questions. Mr. Burnside intended the allusion to the mark because he thought it would bring some, albeit limited and unquantifiable, benefit to his company's business without paying for it. So there's 2 points there, is that there's going to be some benefit to first defendant, and the second point is that benefit is being gained without paying for it. You'll see that there are many references backwards and forwards to judgments that my Lord Justice Arnold has been in, because this matter comes backwards and forwards quite often. See in particular the remarks of Mr. Justice Arnold, who then was in paragraph 300 of W3 cited above. The metaphor of other authorities, his company was riding on the coattails of the EasyJet mark and the members of its family. This sort of calculated behaviour, albeit probably lightly calculated, is in my view plainly taking unfair advantage of the mark. It is hard to see why it would not be unless it was so hopeless to be ineffective, which this effort was not. That last point goes to the point about if somebody's straining to infringe a trademark, then the court will be slow to find that they failed. unless it was so clear that their attempts were just simply pathetic. So that's an allusion to that.
But this is all on the basis that in the few previous paragraphs, a judge had found there was a link.
Yes, yes. But a mere link is not enough to establish section 10.3 infringement, nor is it enough to establish passing off. And for both those two, well, the second point is the Moroccan oil point, and the first point is the Act in section 10.3 talks about the need for there to be one of the various types of damage to be formed in order for the wrong under section 10.3, but you get to the damage via a link. Does that answer my lordship's point? And then in the next paragraph, if it is necessary to prove a change of economic behaviour in order to establish actionable unfair advantage, I would hold it existed, albeit subtly. The whole purpose of the mimicry is to operate on the mind of the consumer. The consumer, and particularly the retail bidding customer, though probably not the auctioneer, would at least look on ELA with more favour or perhaps less disfavour. This was the intended consequence and amounts, if required, to a change in the consumer's economic behaviour. That is why signs 2, which incorporates 2A and 2B, and 3 were adopted, or so far as sign 3 is carried out on the work of sign 3, maintained. So we had there evidence from Mr. Burnside, the third defendant, that he had deliberately adopted certain changes from sign 1 to signs 2 to sign 3, and the judge held that those changes in essence facilitated the existence of a link, and then he said that because those changes were deliberate, that there was a taking of an unfair advantage. So there's an intention here, we would say, clearly founded in the facts of section 10.3 to take an unfair advantage, which can be cross-fertilized in the passing off context of that there's an intention to misappropriate the goodwill. Now, those are the findings under 10.3, and then if we move to the passing off part, and in particular the misrepresentation, this may be found at paragraph 229 onwards, which is page 173 of the core bundle. So,
would you give me the reference again?
yes, of course, my lord. It's page 173
Yeah,
of
got
the
it.
bundle. Paragraph 229.
Yes.
It goes on to 235, so it's over 3 pages. What I'd like to do, if I may, is just bring out the highlights, but some stage you're going to probably need to read it all in detail, but it's probably quicker if I just highlight the points. The way I started this off was, as you can see in 229, in front of the judge, was I did not put my case as high as suggesting that there had been an attempt to represent that ELA's business was EasyJet's. He put it at the lower level of endorsement or connection. And so that dovetails in, I would say, with the way in which the tort of passing off has developed. 230, the judge at first instance said that I was allowed to do that as a matter of authority, and he goes to the Bulmer-Bollinger case. And looking at the last sentence of the quote in 230, thus, for example, it would be sufficient if they were taken to be made under license or under some trading arrangements, which would give the plaintiff some control over them. So this echoes the sort of the licensing type points that you pick up from Fenty and the Rihanna case. At 231, the judge said that I had a good starting point, and in particular, if you turn the page, the third line, that being the case a connection with EasyJet was intended in the sense that it was intended to suggest that ELA's business was somehow connected with the EasyJet brand. Just as I was prepared to conclude that there was a link for the purposes of section 10.3, starting from Mr. Burnside's intention to create one, I consider it right to take that intention as a strong starting point in the inquiry as to its effect for the purposes of passing off. I'm going to refer to paragraph 232, even though it's an en passant mark because it rises in a slightly different context, but it's sufficient to refer to it here, so we don't have to come back to it. There's a point about a pleading point about whether or not all this intention to deceive was pleaded properly. And the long and short of it was the judge said in 232, it was not unfair to mount that challenge that there was an intention, and that he has had, he in that case being Mr. Burnside, a fair opportunity of rebutting it. It's slightly out of context, but because the paragraph's there, it's quicker so you know where it is. We then proceed on to 233, paragraph 233, page 174. The evidential value of the intention is also apparent from the decision in the Australian Woolen Mills case. And from the quote, the rule that if a mark or get-up for goods is adopted for the purpose of appropriating part of the trade or reputation of a rival, it should be presumed to be fitted for the purpose and therefore likely to deceive or confuse, no doubt, is as just in principle as it is wholesome in tendency. My lord, that rather deals with your point about principle. I think Ray and the evidence point.
Well, I think actually the principle is in the next sentence, isn't it? That the instinct and judgment of traders is
Yes,
not to be lightly rejected,
my-
which is the point my lady was making.
My lady made exactly so. And then the hanging paragraph at the end of 233, so it's on the next page, 175. It is unnecessary to brand Mr. Burnside as dishonest for these purposes, and I do not do so. But his deliberate acts fit with the principle in that case. So, I mean, there's a difference there between saying the witness is dishonest and with respect to, he denied that there was any link. The judge found that there was a link, but you don't need to find there is a link and find the witness is dishonest in his evidence, as you well know, my lord. You can say, I hold against him on whether or not there's a link, but that is his view. He is the witness's view. So there's a distinction there. So the fact that he, the witness, was not branded as dishonest, we say is neither here nor there. What is important is the deliberateness of forming the link was found to be so. And then this is summarised in paragraph 235. I therefore find that the deployment of signs 2 and 3 amounted to a relevant misrepresentation of connection between ELA and the EasyJet brand and its family, and it would mislead a relevant portion of the average consumer, particularly the bidder consumer. So, what we have there is that we have an intention that was found by the judge to appropriate something, the goodwill, the reputation, that carries over from the 10.3. And the finding of misrepresentation is a multifactorial finding. You can see the way in which the judge has discussed it in detail throughout those paragraphs, and also there was a multifactorial analysis with respect to the way he dealt with the issue of link with respect to 10.3. You saw the way in which he was couching it, saying that it was a subtle link and all those sorts of things. But then we come to the denouement with respect to passing off. Having held that there was not only a link and an unfair advantage so as to satisfy 10.3, and also having held that there was a protectable goodwill and a misrepresentation with respect to the intention to misappropriate the goodwill, the judge at first instance reaches his conclusion in paragraph 237 on page 176 of the bundle with respect to damage. So, the occurrence or the likely occurrence of damage is the next ingredient of the tort which has to be considered. Here, Mr. Edinburgh's case fails. Although I have found an intention to forge an otherwise absent connection, I do not consider that there is sufficient evidence of the likelihood of damage. There cannot be any realistic suggestion of the diversion of any trade. Well, I didn't put my case like that because of the absence of any real similarity or overlap of the businesses of the claimant's franchisees on the one hand and of ELA on the other. Nor, in my view, is there any real likelihood of damage to the repute of those brands. That is a potential head of damage under section 10.3, which could be taken unfair advantage of or detriment to the distinctive character or repute of the brand. And the judge at first instance did not make a finding on that. He didn't say there was damage to the repute. I consider that the poor reviews on Trustpilot, which were in evidence, are unlikely to be carried over to the EasyGroup brands in all the circumstances, despite the connection created by Mr. Burnside. These were reviews of the ELA of the defendant. Mr. Edinburgh relied on benefit to the defendants in being able to use signs 2 and 3 without a license as giving rise to damage, because the ability of the claimant to charge others for a license would be diminished. But I'm afraid I do not understand that logic. So that's clearly a failure in my ability to explain to the judge what I've tried to explain to your lordships and my lady just now, that when you look at the particular wrongful act, the particular type of misrepresentation that has been found in this case under section 10.3, that wrongful intention to misappropriate the good, so the goodwill or reputation that's associated with the claimant, can satisfy a satisfactory head of damage for the purposes of passing off. And that's predicated upon the wider form of passing off, whereby some sort of unlicensed use, you'll remember that, of the goodwill is a wrong that can be protected by the tort of passing off.
Well, you said that that can form a head of damage, and no doubt that's right. Is the judge's rather cryptic statement that he doesn't understand the logic, is that a proposition of law, or is he saying you haven't proved it on the facts that there would be any impairment of the EasyGroup's ability to license its brand? What does he mean by that?
My lord, I would say that it's the first of those, not the second, because he seems to just simply deny the possibility as a matter of law that what he's established as a wrongful act for the purposes of 10.3 can also satisfy the requirements for the tort of passing off. And in my submission, it's clear that a misappropriation, an intention to misappropriate the repute or goodwill of the claimant, that is a wrongful act that can lead to damage that would satisfy the requirement for the third element of the tort of passing off. And to support the last bit there,
Well, it's not really the intention, because the intention was the evidential factor that was relied upon, as you pointed out, as grounding the one of the factors grounding the misrepresentation. So it's the misrepresentation as to a connection that then opens the gateway
yes,
to this head of damage, you said.
yes, that's why I was dealing with misrepresentation and damage together, because they are linked. Because if, for example, arguing against myself, that the head of damage is diverted sales, then it would be necessary to show that the misrepresentation led to those diverted sales. But that's not the case here. I say that the misrepresentation, as my Lord Justice Arnold has said, is with respect to the wrongful association. And that's the channel through which I can then say that the damage is to my licensing ability. And I would say I make that good on two ways. First of all, you'll recall that in paragraph 216, the judge said that there was a benefit to the defendant and he had not paid for it. So there's a direct loss there of actual licensing income. And the second is a more general point, which is that if you have a claimant in the situation where they're in the business of licensing and there is found to be wrongful behaviour by the defendant and they're not paying for it, then that speaks more widely to the market at large that you can get the benefit without paying for it. And so therefore there's an overall damage to the licensing goodwill. And you'll remember it was expressly said in one of the cases that goodwill, you can have goodwill in a licensing operation. That's a sort of franchise or franchisee type situation. And in this judgment, you'll have also seen that the judge, in fact, is in this paragraph, paragraph 237, he does refer to the other sub-businesses of EasyGroup as franchisees.
Yeah.
So,
And it,
sorry,
it
my
might
lord.
just worth picking up. He does say a little bit about this in the judgment at 61, paragraph 61 on page 192.
Yes. I haven't gone through all the sort of the history. The way in which the judge dealt with this, I think, was in paragraph, just 1 second.
Well, there's the incorporation by reference of W3,
Yes.
and he picks up the general points that EasyGroup holds the IP rights and is licensor at 54. But at 61, he makes the point that EasyJet was a licensee and various other
Yes.
of the operating businesses were also licensees.
And one of the ways in which the cross-examination started with Mr. Burnside was because there was actually a pizza flyer, Easy Pizza, that triggered off the whole debate because supposedly the second defendant, Mr. Achilleos, bore some resemblance to Stelios, and it was supposed to be a joke with him amongst the defendants. But the point of that statement is to show that at the time, there's an Easy Pizza, which was a licensed operation, and the Easy Pizzas, as a production and distribution of pizzas, is quite far removed from the business of EasyJet, even though one might get a pizza on a plane. But you see what I mean? Is that it's not travel services and airplane services. It's quite different.
So I think your point here is that the finding in paragraph 216 is a sufficient finding of fact to open the gate to this head of damage.
My lord, yes, 216, 217 when read together, but it starts with 216, absolutely, and in particular that finding that there was no payment for the benefit.
So you put the point, I think, in two possible ways. Insofar as the judge is saying that this head of damage is not open to you as a matter of law, that is wrong in law.
Correct, my lord.
And if he's saying that you haven't proved it on the facts, then his finding at 216 says the contrary.
Well, exactly. I mean, it sort of, you can't have the finding of no damage if he's also found that there's been cannot have a finding of no damage in passing off if he's found the relevant damage in 10.3.
Yes.
Yes, exactly.
Yes. Well, he's found that the defendant has an unpaid for benefit
Yes.
from the Easy brand.
My lord, yes. And sorry, my lady.
Yes, that his finding goes to the first of the two elements of damage that you just described. You described two. One was not paying for,
Yes, the
the
crystallised damage.
use of the
Yeah.
name. But you then made another point about the position of the market at large
Yes, my lady.
and potential loss of licensing income, presumably from others saying, well, he's not paying for it.
Yes, my lady.
But there are no findings in relation to
No,
that.
the way in which I put it, my lady, remember the Fine and Country case?
Yes.
And I'm afraid I very quickly did it, but it was with respect to the latter paragraphs to which I draw the court's attention, which was future issues.
Well, if you establish, I mean, I assume this was a trial on liability only, as
Correct.
as the
Yes.
IP cases
Yeah,
usually
exactly,
are.
Exactly.
So you wouldn't have to show the full extent of your damage at the liability stage. You'd have to show some,
My lord, yes.
but the how much damage would be decided on the inquiry.
Yes. Yes.
Now, I can't remember whether Fine and Country was a liability only case or whether the judge actually
Let me
assessed
just say that
damages.
I'm fairly
that
sure
case.
it was.
It probably was because they usually are, but I can't remember.
It would be truly exceptional for an IP case heard in the courts of England and Wales
Yeah,
to
quite.
have the two together.
It sometimes causes problems like proving damage. But there we are. You say you've got a sufficient finding in 216.
And the way in which I go for the future damage, which my lady has just raised, is the Fine and Country point and the paragraphs there, which would be paragraph 76 to 78, 78 in particular. Oops.
Well, that's really ground one, isn't it?
It is. There was just a couple of other points. You can look at this through the eyes of Wadlow. I haven't taken you to Wadlow because it's obviously not a reported case, but it's in essence the leading textbook on the issue of misrepresentation and tort of
These are the
party.
points you've listed in your skeleton argument.
Exactly so. So I can either take you through that, or you can
Well,
take.
we've read the skeleton argument,
In
so
which-
if you want to add anything, please do, but we have read it.
There's
And
probably
we will
this-
assume that you rely on all the points that you put in writing.
Exactly so, and that's why I'm raising it in this way.
Yeah.
But there's the smallest of points, and that is, it has been put that nobody would want to take advantage of EasyJet reputation because it has a very bad reputation. Well, that's got to be read in context, and that is, if you look at all of the airlines, they all have about a 2.0 reputation on Trustpilot. But if you look at the details,
Sorry, there's some evidence and fact finding about this.
well, there is some evidence in the supplementary bundle, and I'll just give you the reference. It's in the supplementary bundle, tab 2, page 18. And the point is, for EasyJet, there's one complaint in every 40,000 passenger.
But what does this go to?
It goes to the fact that if you're trying to say that nobody would try and take any advantage of EasyJet's reputation because its reputation is so bad, actually,
And therefore,
Well,
I mean,
therefore-
what's the legal conclusion that follows?
Well, there's
Assume on the facts that's right. Let's
Yeah, yeah.
assume, for argument's sake, nobody wants to take advantage of EasyJet,
yes,
right? First of all, we're dealing with EasyGroup,
yes,
not EasyJet. And secondly, you've got your finding of fact, and if it turns out that the Easy brand is so useless that nobody will want to take advantage of it apart from these defendants, you won't get much by way of damages.
it just feeds into one of the points in Wadlow about whether there's any real benefit to the person who is taking.
Well, the judge has found there was.
But I was just trying to negate that the other way around.
Hmm.
That's it.
Right.
But otherwise, if you're happy for me to say that if you'd please read my comments on Wadlow in the skeleton, then that deals with that.
Fine.
My lords, my lady, are there any other comments on ground one?
No, thank you.
In which case then, with your permission, I'll proceed to ground two. Now, the point here is that we in essence have two ways of putting it. First, we say that there was no proper foundation, factual foundation, to even consider the granting of a declaration of non-infringement, which I'll sometimes abbreviate to a DNI, and that if there were any base, which we obviously deny, then the actual DNI that was ordered is bad because it is chronically unclear, we say. Now, the first point is...
That's not easy for you, since you invited the judge to make a declaration.
Well, I'm going to deal with that, actually. I need to unwrap some of this,
Right.
I'm afraid. So the very first point is that there was no pleading or mention in the pleadings of a declaration of non-infringement. So there was no mention of it in the skeleton arguments or the closing submissions at trial. There was no evidence led on it. There was no cross-examination on it. And it wasn't even mentioned in the form of order skeleton filed by either party. So it arose in the context of the consequential hearing when we were discussing the injunction relief, or the injunctive relief that EasyGroup sought. Now, the first point that I need to make here is that it's suggested that it was common ground that an injunction with respect to the trademark 10.3 claim should be granted. Well, that was not actually the case, because the defendant's first position was that no injunction should be granted. And you can find that in the respondent's form of order skeleton at paragraph 18, which is in the supplementary bundle, tab 14, page 175. I wasn't going to take you to that because it's just that. It just says that
Yeah, no injunction should be granted.
yes, exactly so, my lord. But it was then further resisted, so to speak, at the actual consequential hearing. Now, you have the transcript for the consequential hearing, and the first thing you'll notice is that I'm afraid issues rather ebb and flow during the hearing, and so it's not neatly set out in ordered chapters, so to speak. But to pick up the point that I've just made, let me just... It's in the core bundle, and it's tab 9 that you'll find the transcript.
Yeah.
And for this particular point, it's on page 187.
Well, I was looking at 186. Manuscript page 9 to 11. You say...
I was going to come to that in a moment, if I may, my lord. I'm sorry.
187.
I need to... I don't mean to cut across, my lordship, but I was going to lay some stones, I hope, in logical order.
All right.
This is page 187, and it's mini page 14, line 16. So the defendants, their first point is, my lord, there is, as I've set out in my skeleton, two groups of issues under this. This is the injunction heading. This is whether an injunction should be granted in the first place at all. Then there are the additional words which are strongly objected to. So there was a fallback position. Whether or not there was an injunction was resisted, and then more strongly resisted was the particular wording if an injunction were ordered. And we, that is EasyGroup, argued for an injunction, first of all, and secondly, that if any injunction were ordered, then it ought to have the wider form of wording. My lords and my lady, might I just take you to the actual order so that you can see the wording that has been added. This is behind tab 11, and it's page 250. Paragraph 5 deals with the injunction as it was finally granted. And 5A, using the below signs and or any sign colourably similar. So that's a conventional wording, and that was resisted. And then if you turn the page to page 251, you're still in paragraph 5, this time subparagraph B, otherwise infringing the registered marks. Again, that's conventional wording and that was resisted, but the judge ordered both of those forms of words. Now, then picking up the point that my Lord Lewison has made, is that the way in which the declaration arose was when I was addressing the court on whether or not an injunction should be ordered. And we go to the previous page in the transcript, 186, and I'm sure, my Lord, this is the reference to which you were alluding. So I am at this stage arguing that an injunction should be granted, and secondly, that it should have the wider form of wording. And at the bottom of page, mini page 9, my submission and suggestion is that you have found that sign 4 does not infringe, so you can make a declaration or a proviso to that effect so that the defendants are fully and openly protected with respect to your finding. So in the form of order skeletons put forward by the parties, they're both completely silent with respect to a DNI. And this is the first time it crops up in the consequential hearing, and it is right to say that I put it forward. But it's in a narrow sense with respect to sign 4, and it's in the alternative to a proviso. So you could make the injunction provided that sign 4 is held not to be encompassed or something like that. That's what I had in mind. And so you can see how it arose. Sorry, my Lord, just making sure. And when I continue to address the judge, it's also on mini page 11 from line 6 onwards. You can protect the defendants concerned by a proviso and or a declaration. We're not going to object to that, crafted in terms with respect to the express sign 4 that you have found not to infringe. That would be fair to the defendants. Now, there's another point that I need to lay by way of foundation before I go on to my overall submission with respect to ground 2. And the way it arose is that further on in the transcript, at page 188, mini page 17, from line 24 through to the next page. This is where my learned friend is addressing the judge. Well, the uncertainty can be alleviated by the grant of a declaration in the defendant's favour, a declaration of non-infringement, which is something that is not in order at the moment. That would go some way, but we say it does not deal with the real mischief we have just pointed out here, and does not go far enough. So I would also have to cover in my submission sign 1 and the plain words themselves, which have not been found to infringe. So there's 2 points that you need to draw from that particular bit. This is where, after I've introduced the possibility of a DNI for sign 4, the defendants then extend it to sign 1, and there was a finding of non-infringement with respect to that. And this is where they introduce the words plain words, the phrase plain words. And it's put here, the plain words themselves, which have not been found to infringe. Now, I'm going to develop this in a moment or two. There's an express finding that sign 1 and sign 4 do not infringe. But there's no express finding that the plain words, whatever that phrase may mean, do not infringe. And this is also relevant to another point that is raised in the skeleton by the defendants before this court, that the DNI that finally appears in the order from the first instance judgment was negotiated with the claimants after the consequentials. That's not the case. What happened was that the order, the form of order, was left for the counsel to formulate, and the phrase plain words, which had been introduced by the defendants, and I will show you later was also picked up upon by the judge, it was thought best to put those words into the DNI. It's not a negotiation between the parties. It is an attempt to capture the words used by the judge in that which he ordered.
Well, that's what he says on page 190, bottom of mini page 25, top of page 26. Whether you should protect plain word marks, and he says at 26, line 4, I'd certainly extend the declaration to those words. So that's what he rules on the form of the declaration.
Yeah. So the point being is those words came from originally the defendant.
Well, that's the judge's decision.
And then
yes.
the judge, yes.
Yes.
So that's why those words turn
Yeah.
up. It's not that. That phrase, plain words, has been negotiated and therefore consented to.
No, I understand that.
Right, that's all the point I wanted to make. So, that by way of general background to this particular ground, might I take you to the law, and then I'll deal with the particular facts as they unrolled between counsel and the judge in consequential hearing. So, I hopefully can deal with this quite briefly. The first authority, which I'd like to direct the court's attention, is the BNP Paribas case, which is behind tab 14. And if you turn to page 397, and paragraph 1, this is the trial of a claim for declaratory relief and, at least in part, negative declaratory relief. And the point about that is that it sets out that normally when you're seeking declaratory relief, and in particular negative declaratory relief, a DNI, declaration of non-infringement, but what you have is the DNI issue front and centre of the case. So it's not something that arises, in essence, when you're picking over the ashes of the judgment of the consequential hearings. It's not something that you do on the hoof at the consequential hearing. It is a very powerful remedy. And in my submission, that should be predicated upon a proper claim, a defence, and a trial upon relevant necessary facts to lay a firm foundation for any granting of a declaration of non-infringement.
Well, all that makes perfect sense, except that you said to the judge that he should make a declaration,
My
albeit a
lord,
limited
yes,
one.
But
I mean, if you'd said to the judge, this is quite wrong, you should not be doing this on the hoof, we need to adjourn this and have some proper pleadings if we're even going to think about a declaration, that would be one thing. Now, you said you had 2 points, no declaration at all, and if declaration, then not this one. And I suggested to you your first point was quite difficult, and this BMP case doesn't go to that.
Well, I'm going to develop it,
All
but
right.
my lord. But the point is, you're right. But bear in mind, what I did suggest to the judge was a DNI with respect to sign form.
That I understand. That goes to the form of the
Yes,
declaration.
exactly. So, and the reason for that is because there had been a finding, but everything else, I say, is unfounded. So, developing that latter point, if we stay within BNP, but now turn to paragraph 66, which may be found on page 413.
Yeah.
The authorities clearly indicate that a court should be cautious when asked to grant a negative declaratory relief, because while negative declarations can perform a positive role, they reverse the more usual roles of the parties, and this can result in procedural complications and possible injustice to an unwilling defendant. In addition, a declaration will normally make the issue raised judicata, so as to prevent the defendant from subsequently bringing an action to vindicate the right denied to him by the declaration. It is the raised judicata implications of granting a declaration which make the question of the grant of a declaration particularly acute, where there may be a danger of the dispute not being fully contested in the proceedings. And so what we get from that is that you have to be quite careful in the way in which the forming of the declaration, or even the consideration of whether a declaration should be granted, has to be taken into account so as to ensure there's a proper foundation for everything. And then, in this case, the last bit to which I'd like to draw your attention is paragraph 78, which is on 416. And in 78, there's a number of points, but in little Roman 4, the court must consider whether the grant of declaratory relief is the most effective way of resolving the issues raised. In answering that question, the court should consider what other options are available to resolve the issue. Now, I just want you to bear that in mind, because the judge does actually, when we look at what happened in the exchange between counsel, raise other issues, and that seems to hark back to this, even though this case, of course, was not drawn to his lordship's attention, because, of course, nobody thought about a DNI until it turned up. And then just turning the page, this is under little Roman 5, subparagraph A. The court will not entertain a purely hypothetical question. It will not pronounce upon legal situations which may arise. So that's a general point, that you shouldn't cover off hypotheticals. The next case is the Skyscape case, which is authority bundle behind tab 9. And head note 5 is a useful summary on page 230. In the present case, the issue was not sufficiently clearly defined to render it properly judiciable. The initial DNI covered too large a number of combinations of signs or services, and variables being such that there was a kaleidoscope of possible outcomes, which introduced an unacceptable degree of uncertainty. And then the last sentence of that head note: the burden was on Skyscape to establish that the use of its sign would not amount to infringement. And to make good those points, if you turn to paragraph 22 within that judgment on page 237 of the authorities bundle, if I can pick it up on the bottom line, and it's the beginning of the last sentence on that line of paragraph 22, Mr. Justice Kitchen was not being asked to make fresh findings on a long series of points neither party had directly addressed. We say that that's a particularly relevant point because you shouldn't be at the consequential hearing be trying to make fresh findings that are not firmly established within the judgment. And we can continue at paragraph 26, which is on page 238. Skyscape can have been in no doubt that it was required to list exhaustively and unambiguously all acts in respect of which it wanted a DNI, all combinations of signs and services. This in essence reiterates the point that you really have to have a very clear formulation of what you're trying to seek a negative declaration about because of the risk of shutting out by the mechanism of res judicata what would otherwise be a proper suit, a proper claim. And that's picked up in the last two sentences of that paragraph 26. That being so, Sky was entitled to take the position that if the court were to be persuaded that Skyscrape was not entitled to any part of the declaration, the DNI would be refused. And that just reiterates it from the other way around. That if the DNI is too wide, and so you're not entitled to it, then the DNI is at fault and it shouldn't be granted, certainly not in that form. And then, just to make good the last point in the head note, on page 243 of the authorities bundle, paragraph 52 of the judgment. In the case of an application for a DNI, the burden is, of course, reversed and becomes a correspondingly heavy one. So, in essence, the burden is upon the party that is seeking the particular relief. Now, that is by way of setting the legal framework against which we look at what happened in this case. And if we go back to the core bundle and back to the transcript of the exchange between the parties and the judge at the consequentials hearing behind tab 9. Again, I'm afraid I need to lay a few foundation stones before I come to the central point here. But the first point is, you remember when I said in opening that there were some other issues between the parties. One of those other issues was whether or not EasyJet could invalidate the defendant's trademark registration. So that's the application for a declaration of invalidity. Now, the judge didn't decide upon that in the main judgment, and so that issue turned up in the consequential hearing. And what I'm going to take you to is how the judge dealt with that. And you'll find that on page 198 of the bundle. And it's mini page 57. Oh, sorry. I have got a false reference. Oh, no, sorry. It's through to, it's line 9 on mini page 57. this is where the judge is making his finding on the application for a declaration of invalidity. Accordingly, I consider that Ms. Riedenberg's second line of argument also fails. So that's my second line of argument about whether or not there should be a declaration of invalidity. It follows from that the application for the declaration that is sought fails, and Mr. Aiken succeeds on the point. So that's where the judge finds against me on my application for a declaration of invalidity. But if you look at his reasoning, which starts at line 3 on mini page 57, he's talked about the fact that the registration of the mark may not take unfair advantage of the claimant's mark. If the deployment of the mark, that is the defendant's trademark, in due course infringes, then it will infringe. But it does not follow that the mere existence of the mark on the register somehow takes unfair advantage of the claimant's marks. There is no free riding or coattail riding at that stage. And so what the judge is expressly acknowledging at that point is that with respect to application by EasyGroup to declare invalid one of the defendant's trademarks based upon the 10.3 allegation, that fails basically for want of evidence. And he's looking at that in essence as a paper exercise. But he's holding open the door that potentially, even though the application for a declaration of invalidity has failed, and therefore the defendant's trademark stays on the register, if the actual deployment of the defendant's trademark that's on the register is done in such a way that when you look at the issue through the eyes of the infringement scenario, it might infringe. So he's held against me that I can't knock the mark off, fine. But he's left open the issue that even though the mark is left on the register, its future use might infringe. And that seems to be his reasoning. Certainly that's what he says. This is all, of course, in the context, there's no proper judgment on the DNI. So we have to try and draw together the threads that are from the interaction between counsel and the judge. And I do pray that in aid, that he seemed to, at this stage of the consequential hearing, think that it was possible that the mark which he allowed to stay on the register might infringe at a separate point in time. And so therefore, you cannot equate a failed application for a declaration of invalidity with the fact that those marks that are left on the register do not infringe. That's a false jump. And that's because there's different considerations when you're considering an application for a declaration of invalidity versus the issues that you have to consider when you're looking at infringement. And yet, it is exactly that false association which the defendants tried to form later on. Now, I'm afraid we are going to jump around this transcript a bit because what happened was that various things were treated in turn, but the DNI issue was treated substantively right at the end, after everybody had thought everything had been finished. And so we now need to go to the end of the transcript, and it's on page 216. And it's mini page 130. So starting at line 2, the judge says, you mean that you have your declaration about sign 4, that's the bit that I proffered up. you want the declaration in respect of the word marks as well. Is that your point? And my learned friend says the plain words, yes, exactly, to reflect the finding on invalidity and to give the defendant certainty in that respect. Now, in my submission, that's a sleight of hand. You cannot make that step from a failed application for a declaration of invalidity to saying that you should grant a declaration of non-infringement. And part of the reason I say that is because the judge himself recognised in the quote to which I took you earlier that there may be different considerations that apply. And of course there's a further point, and that is the burden of proof is different. For an application for a declaration of invalidity, the burden is upon me because I'm seeking that. But the burden is reversed and is upon the defendants when they seek a declaration of non-infringement. Again, I showed you that in the case law. Now, the next point I need to take you to is that there was no express finding that the words, as opposed to the signs, did not infringe. Now, with respect to the 4 signs that were set out in
Just before we go there,
Yes, my
can
lord.
we just look at what you said about the principle of any declaration? Page 130, bottom of mini page 130, lines 24 to 25, you again say that with respect to sign 4, I was happy to accede to the declaration because there was a clear basis for it.
Yes, I mean,
I entirely understand that you say that the declaration the judge granted was in fact too wide. That I understand that. But you are, as I understand it, still maintaining your position that he shouldn't have granted any declaration at all, despite the fact that both at the beginning of the consequentials hearing and at the end,
Sorry,
you said
my
you were
lord.
quite happy for him to do
no,
so.
no, my lord, I mean, that's entirely my fault. Sorry. It is entirely my fault. With respect to the way in which I draw my lines in the sand, is the first line is very faint. And that deals with the point about no declaration at all. I draw another line, and that is sign 4, yes.
Well, that I understand, but I'm concerned with your first line in
My
the
first
sand,
line,
because that was your first submission on this ground was
yes, yes.
the judge should not have made any declaration at all.
No, my lord, it is a very faint line, and if you wish to trample me and trample over that line, I'm not going to resist any further.
Right. Well, I would be very reluctant to find that the judge was wrong to do something which both sides invited him
My
to
lord,
do.
yes, exactly so. I mean, I can see your point. Does that explain it sufficiently that I don't
Yes.
need to come back to it again?
Yeah.
So my more firmly drawn line in the sand, he says, I started off with sign 4. The reason for that is that practically sign 4 is what they now use. And so if they want comfort with respect to what they now use, then a sign 4 declaration obviously has utility. There is another faint line behind that, so to speak, and that's with respect to sign 1. The reason why it's a faint line is because sign 1 is of historical use, only of historical interest. The use stopped ages ago. There's a small possibility they might go back to it, but the point is the judge did make a finding of fact in respect of that. And so therefore it does fall on the same logical basis as sign 4. But the very, very firm line I'm drawing is with respect to the words
Yes.
that then follow.
Yeah. Right, you wanted us to go to, you said no finding that plain words did not infringe was the
Yes, and
point you made.
now, in the skeleton before this court, at paragraph 60 of the respondent's skeleton, I wasn't going to take you to it, I was just going to give you its gist. For your note, though, it's the core bundle, tab 6, page 73, the respondents do say there's no express specific finding on the plain words. Well, that's not really surprising because you won't find one within the judgment, but it does need to be said. And then you can see the way in which this all arose with respect to plain words phrase. It starts off in the transcript you'll find it on page 188, and it's mini page 18. And what's happening here is you're getting an exchange between my learned friend and the judge. This is the first time the DNI issue turns up. That's why we're jumping backwards and forwards between the beginning and the end. And what happens here is my learned friend at 15 says, so that is the bare minimum, we say, that would need to be included in the order in order to relieve some of the uncertainty. We say that it would not go far enough either. The judge says, sorry, the status of the plain word mark, that was not the subject of the actual challenge. That was not the subject of the action. The subject of the case before me was signs 1 to 4. And then my learned friend goes on to say, the use of the words was alleged to infringe, and my lord has not made a finding that they have infringed. Indeed, an injunction is not sought to restrain the use of the plain words themselves. So it's true, there's no finding that they would infringe, but correspondingly, there's no finding that they would not infringe. And you can partly see how that arose, that the judgment is silent on that particular issue, because the judge himself said that he thought that the focus of the case was on signs 1 to 4. And that harks back to the way it was pleaded in the particulars of claim that I took you to in the opening, with respect to setting out the signs, even though I do have to admit that in the claim form, the wording is wider. And actually, there's another point against me which I'll make, and that is in the EasyGroup's closing submissions, it's also mentioned in a wider way. If I can just find that, give you the reference. It's in the supplementary bundle, tab 11, page 124, and it's paragraph 46. It's just so you have that point against me.
So it's the first three.
Exactly.
So, yeah.
Yes. So that's against me. But you can see that what was in the mind of the judge was in essence what followed after those first three was signs 1 to 4.
Yeah.
And then, I'm afraid we now need to go to the end of the transcript, is when the DNI was properly fully debated. This time on page 217, mini page 132. And this is where we have an exchange between my learned friend and the judge. Starting at line 2. The difficulty the defendants are in at the moment is that there is the injunction, the wider form of injunction that we have at the moment, and there is not an express...
Beg your pardon, it's my fault. I haven't found the reference. Could you give it?
Sorry, my lord. We're on the transcript, which is tab 9 behind the whole bundle, page 217.
Yeah, and we're in the ministry.
Mini page 132, top left-hand corner. And I was starting from line 2. The difficulty the defendants are in at the moment is that there is the injunction, the wider form of the injunction that we have at the moment, and there is not an express finding in the judgment that the use of the plain words does not infringe. So that's the point. The judgment's silent on this matter. Of course, There is the use of the plain words at the moment. That has been since the very beginning. The judge, was use of the plain words actually the subject of the action? That harks back to, remember what I've just shown you on mini page 18, line 18. Mr. Akins, it was pleaded to be an infringement. I've shown you how that was yes and no. It was raised in the claim form and in the closing skeleton by EasyGroup. If they tried to say that the plain words were an infringement, then the judge is cut off. They have not succeeded on that. The judge, they have not succeeded on that. I am not sure I said much about it. That's true. He didn't say much about it. They have not succeeded on it, but they would not be able to run that because they do not have a finding. And there would be broad issue estoppel from running it, basically. So that harks back to the case law on there are other ways to skin this particular cat, that you don't always have to grant a DNI. There are cases, and my Lord and Lord Justice Arnold has said this expressly, that the judgment is sufficient to give guidance to the defendants and third parties on what is the scope of the judge's finding in any particular issue. Or there might be other things that arise, and the judge in this case, at first instance in the consequential hearing, has mentioned the issue of estoppel. So that would presumably be a Henderson type matter. So there are other ways that this can all be resolved.
But that's not a terribly satisfactory way of resolving anything, is it? I mean, Henderson, you'd have to go right back into the history of the action, what you could have raised, what you should have raised, how connected it is to what you did raise. This is can be quite a big inquiry to work out whether
yes,
a Henderson type estoppel applies.
My Lord, it could be quite a big inquiry, but in this particular case, it might not be so large.
Yeah.
So, in principle, yes, it could be wide. I'm not saying it's a perfect solution. All I'm saying is that the judge himself mentioned it.
Yes, indeed.
And that's as far as I take the point. And so what I draw from this in particular is that if the judge himself has recognised that he hasn't said much about it, you cannot take that silence on the issue to equate with a positive finding that the plain words do not infringe. And so the way I'd put it is that with respect to the plain words element of the DNI, that should not be granted at all because there was no proper foundation. So I'm now probably on my fourth line in the sand. But, that's the way I put it with respect to there was no proper factual foundation to grant a DNI vis-a-vis the plain word phrasing, moving signs 1 and 4 off to one side. Now, indisputably, the grant of a DNI is an issue of discretion for the court whether or not one should be granted. But there's a suggestion that the meaning of any DNI that is granted is also a matter of discretion. The way I would put it is actually that the meaning of a DNI is a matter of construction. Once you've written those words down, it is then for, it's a standard sort of contractual statutory construction point that certainly my Lord Lewison will know all about on the grounds that you've written the book on it. So that's the point, is that that's an issue not of discretion, it's an issue of construction. And then we come to this second point, which is that even if he could have granted something, then it's the plain wording, sorry, it's the plain wording that is at fault, because it's just simply unclear. And the way in which I'm going to start this off is staying on the same mini page 132, is that what you then have here is a little bit of debate about Cooper Black. For those of you who don't know, the EasyJet and those Easy type brands, that is a particular font that's called Cooper Black. I know my Lord Justice Arnold knows all about this, but I'm not sure everybody else knows about it.
Well, I think you told us about it in your skeleton argument.
Oh, probably, yes. I should have done anyway. But the point is that it's a particular font. And this is where I need to apologise, because you know we gave up to you the PDFs of the skeleton arguments. I was unaware that the PDF altered the fonts. I thought it produced everything perfectly. That's why everybody uses a PDF. But it did alter the fonts. That's why I've handed up a separate page with the fonts from a Word document, which is how they were produced originally. And that's why I'm afraid you have a single sheet that is astray. That's my ignorance of how Adobe work. Anyway, we now get into this issue about Cooper Black. And we're still on the same page, mini page 132. My own friend, yes, that is what we say the position is now. That should be reflected to give certainty for everybody in the order. And the judge at line 21, the problem I have with that is, what does the declaration mean? Unless you qualify it with the words without more, the plain text, does it cover, supposing you were to start to use them with Cooper Black, for example? My learned friend responds, we would accept the inclusion of the words without more. It seems that they're at cross purposes, but clearly the judge has raised the issue of whether the plain words would or would not allow Cooper Black. And it seems to be that the respondents, the defendants, are saying that you might be able to avoid some sort of ambiguity in the construction of the declaration that was granted by the addition of the other phrase, without more. But, and this is where we get to a little bit of a problem, is that this debate continued, and if you turn the page to page 218 of the core bundle, mini page 136, now the debate has moved on, and we're now looking at the word in non-stylized, non-logo form. My learned friend, line 6, yes, my lord, that is my proposal. The judge, in non-stylized and non-logo form, Mr. Edinburgh, I respond, my lord, Cooper Black is non-stylized and non-logo form. It's as simple as that. So if you use that word, that phrasing, you'd still capture Cooper Black. But my learned friend says, no, we do not accept that. And so this illustrates, in my view, that there's clearly an uncertainty in the wording that has been proposed. In my submission, Cooper Black, which you have on the separate page that I've handed up, is clearly non-logo form, and we would say it's non-stylized form as well. So
It's just a particular font.
that's
Otherwise, how do you distinguish between, say, Times New Roman and Arial?
my lord, that's exactly the point I was going to make next. You haven't read my notes, but yes, it's the name of a font. It's the name of a particular font, yes, but it's not some fancy font, we would say. That's the point. It's as simple as that.
Yeah.
So we say that the wording that ended up, excuse me, in the, excuse me.
So if we go back to the order for a moment, tab 11, page
I was just
250.
going to take you there, but
Yeah.
sorry.
If you're first line in the sand has been walked over.
We're about fourth line, my lord.
Yeah.
Just,
Paragraph 3A and B stand,
my lord, yes, page 250.
yeah, and C and D, or C goes, and D,
Well, we would say 3 absolutely,
Mhm.
because of the problem.
3C, yeah,
Sorry, 3C, yes,
Yeah.
my lord. Because of the word in plain text without
Yes.
more in non-stylized, non-logo. 3D goes because there's no proper foundation, no factual foundation. And I was going to show you, if I may, the multitude of uses that do occur. And this is in the supplemental bundle. So supplemental bundle, tab 1, page 3. If you look at the top in the blue banner, that's sign 3, if you can see that.
yeah,
If you look at the very last line, which is in the grey box at the bottom, you can see copyright notice 2015, Easy Live, open
Sorry,
print.
which page are you on?
Page 3, my lady, behind tab 1. It's the-
right, I've got that page and I've seen Easy Live Auction at the top. Where's the copyright?
The very last line at the very bottom in the grey box, my lord.
Under legal? No.
No,
Grey box. Oh,
no,
I
it's
see,
right-
yes, I've got
the
it,
very
yes,
last line.
yes,
You've got
Easy,
it now.
copyright Easy Live Services Limited.
Yeah,
Trading
trading
Easy,
as.
yeah.
And that's Easy Live Auction, 3 words, capital E, capital L, capital A, no emboldment. So that's another use of the words, but with particular capitalization. What I'm going to show you here is
Well, that's part of 3C, isn't it?
yeah.
I was asking about 3D, the domain.
That turns up on page 5, my lord.
Right.
So I was just dealing with this in
Yeah.
page
Yeah,
order,
fine.
if you see what I mean. It's in the very top, my lord.
Yes.
You've got that. But then the purpose of this is just to show you that it all turns up in different ways. Page 6, Easy Live Auction, lowercase e, capital L, capital A, no.com, no emboldment either way around. And then at the very bottom you have sign 2A.
Yeah.
If you go to 13, if you look at the blue writing at the top, the second line of which is easyliveauction.com, that's not quite sign 4. You can actually see sign 4 at the bottom in the middle column. So what this has in common with sign 4 is lower e, lower L, capital A, but it doesn't have the emboldment of auction.
Yeah.
And so, and if you go to page 14, can you see the contact details on the bottom right?
Yes.
The bottom right-most thing is sign 2B, but it's also in the context of other various uses of the word. And so the point being is that that's potentially the context in which you would view those other usages.
Yeah.
But
And in fact, the designation of the website
is different.
is different from what appears in 3D of the order.
And yes, and also, my lord, it was page 3, was it? No, page 5, to which I drew your attention for the second time. It's at the top, my lord. Page 5, right at the top in the...
Yes, well, right at the top, is the same as the order,
Yes, yes,
but page
Right.
14
It's
website is not.
it's different, yes, my lord. Sorry,
Yeah.
So you see, my lords and my lady, that this exhibit shows you there's a multitude of ways in which it is actually done. And there's two other big problems with respect to the DNI as it currently exists. Is that it's not limited to any goods or services. And the second point is that it's not limited in any colour. And I think it's fair to say that the way in which the EasyGroup and the EasyJet marks are used are commonly used with that striking orange colour. And one of the noticeable things about this case at first instance was it was the first time that EasyGroup was successful against an alleged infringer that had used an allegedly infringing sign that was not in orange, and that was not for travel services. So the orange bit is important. That's been invoked successfully in other cases for obvious reasons. Sorry, my lords. So, sorry, my lord. So, my lord, that's how I put my case with respect to the DNI.
Yes.
Unless my lords and my lady have any further
Can I
questions.
ask you this? Some of the problems, at least to which you've drawn attention, could be addressed by limiting the form of the declaration, and in particular paragraph 3C. If one added in at the end additional wording along the following lines, as used by the defendants prior to the 13th of October 2022. The reason why I take that date is it's the last date of trial, and therefore provides a convenient cut-off point for what people would have known about by then. And the point about that sort of qualification is it cuts them off from doing Cooper Black because they hadn't done Cooper Black in the past.
My lord, yes.
Likewise, Orange.
My lord, yes. But in my submission, it suffers from the problem of trying to draft something on the hoof as, in essence, a form of order hearing. Just happens to be before your lordships as opposed to the trial judge. And that it should have been, in my opinion, if you want a declaration of non-infringement, it ought to be for a particular, well-defined, narrowly defined thing that ought to be the subject of a claim, defence, trial, and what have you, evidence. And trying to draft this thing in that sort of way still suffers from that, in essence, procedural unfairness. And that was pointed out in one of the cases to which, the first case to which, the BMP case to which I drew your attention.
Well, I quite take the point that you say it was highly undesirable for this DNI to be dealt with in the way in which was done before the judge, because it came out of the blue in essence. Nobody was properly prepared for it. It wasn't properly argued because the issues hadn't been properly defined. I understand all of that. But supposing that we take the view that some kind of declaration of non-infringement was appropriate in principle, but there is a problem with the drafting precisely because of the way in which it was done below, first of all, do you say that it would not be open to us to substitute a more limited declaration? Secondly, what as a matter of substance, if we can do it, is wrong with what I've suggested to you?
Dealing with my Lord's questions, I hope in order, it is open to this court to exercise their discretion afresh. So therefore that would allow you to, in essence, redraft the DNI, to put it in short. The second point is that you do not have all of the evidence that was before the trial judge. And in particular, I'm reminded of my learned junior that there was some use by the defendants of the colour orange in some of their material, which is not before you now.
Right, you've seen it in the supplementary bundle. Page 14 has orange on it. Not in the signs, but on the page.
Yes, but
Sorry, page 13.
13. But I actually think there was some use of orange with respect to the wording. I can't remember the precise details, but I do remember there were a few.
Right. All right. So we haven't got all the evidence.
That's the point. That's as far as I wish to take the point.
All right. So just picking up my Lord's point, you would say that although in theory we could exercise our discretion to modify the declaration, we shouldn't, because we haven't got all the evidence. What about remitting it to the trial judge to reconsider the scope of the declaration, he having heard all the evidence, and if necessary directing pleadings, position statements, whatever you want to call them?
My Lord, again, there's 2 points. The first point is that because of, in essence, the way in which I phrased my case both before this court and below, you would be able to redraft the declaration to include a DNI against signs 1 and 4.
Yes.
But beyond that, to deal with your second point, my Lord, of a remission, well, there's nothing stopping you doing that. But if you then read the transcript, you could see that one of the things the judge was concerned about was how it was going to spiral.
Yeah.
So what would actually happen? It would be, in essence, a new action, because picking up on your lordship's point, there might well be pleadings vis-a-vis the DNI. And as soon as you do that, you're basically into a new action.
Right, I follow.
Because there's got to be some clear statement of what they want a DNI in respect of.
Yeah.
There's going to have to be a rebuttal to that. Then there might well be evidence, one way or t'other, by both sides, presumably. And then there might even be oral evidence. Sorry, I'm speculating now.
Yeah, no, I follow. Anyway, you're saying it opens up a can of worms, basically.
It's, well, you can do what you pretty much like, but I wouldn't recommend it in this.
Yes,
I wouldn't be acceding to that. If you see what I mean.
All right. Anything else, Richard?
No, you're.
Thank you very much, Mr. Edinburgh.
My lords.
Yes,
my
Mr.
lady.
Akins.
My lords, my lady. According to the agreed order, it is now for me to address your lordships, my lady, on both grounds 1 and 2 and the respondent's notice arguments. Because ground 1 and ground 2 are quite distinct, and because the respondent's notice arguments relate only to ground 1, I was intending to deal with those two together. So ground 1, the respondent's notice.
Whatever order suits you.
But first, so dealing with ground 1 and the respondent's notice, I'll summarise my case on both of those aspects of the appeal first. My learned friend's point on the law on ground 1 is wrong, we say, and that's that the findings on section 10.3 in paragraphs 214 to 217 of the judgment are not transferable and do not make out a case by themselves for the damage element passing off. And if that falls, then the finding of no damage was a multifactorial assessment that was open to the judge. And in fact, I don't understand my learned friend to be challenging that if his point on the law fails. If I'm wrong about ground one, and the judge made an error of principle or law in his finding of no damage which justifies interference with this court, then it's also necessary to review the judge's finding that the respondent's use of signs 2 and 3 amounted to an actionable misrepresentation. And in our submission, there are various material defects in that decision which do justify interference. And in particular, the judge erred in relying on the finding of the third defendant's subjective intention in designing signs 2 and 3, made in the context of the determination of the claim for trademark infringement under section 10.3 by reason of taking an unfair advantage. If reliance on that subjective intention is removed from the judge's analysis of misrepresentation, then the court is justified in assessing that afresh, and the absence of that factor tips the balance in favour of no misrepresentation. My lords, my lady, there is a golden thread running through the respondent's case on both ground one and the respondent's notice arguments. That is the question of whether findings made in the context of the claim for trademark infringement under section 10.3 are transferable to the assessment of a claim for passing off. My overall submission under both ground one and the respondent's notice is that they are not transferable.
Yeah.
Thus, the judge's finding of no damage in the claim for passing off is wholly consistent with his finding that unfair advantage had been taken. Now, I can go further than that in the context of ground one. A finding that the damage element had been made out would be inconsistent with the judge's other findings. In particular, his dismissal in paragraph 218 of the judgment of the claim that detriment had been caused to the distinctive character or repute of the trademark. My learned friend didn't take you to that paragraph, but I will do in due course. And of course, that finding hasn't been challenged by EasyGroup on this appeal. So that's why ground one should be refused. By contrast, the judge did make an error by transferring his finding that the third defendant subjectively intended to create a link between signs 2 and 3 and EasyGroup's trademarks in the context of, in the mind of the defendant's customers, and by doing so intended to bring some benefit to the Easy Live auction business. The error was transferring that finding to the assessment of misrepresentation in the claim for passing off. An intention to create a link for the purposes of section 10.3 infringement is not the same as an intention to deceive for the purposes of a claim for passing off as a matter of law.
Yes, I think Mr. Edinburgh accepted that.
So, but the point is, my lord, is that the judge's finding in the context of 10.3 was an intention to create a link. That was what he was carrying over to his analysis of misrepresentation, and that is not sufficient for an intention to deceive. They're different beasts. Therefore, the judge should not have taken into account Mr. Burnside's subjective intention at all in assessing misrepresentation in the passing off claim.
Well, the judge found not only, under 10.3, not only was there a link and an intended to create a link, but that the defendant took unfair advantage of that link.
Yes, by an association.
Yes.
In the mind, the illusion in the mind of the customers, the defendant's customers.
Yes, that the defendant was part of the Easy family or endorsed by the Easy family? Or
With respect, no, my lord. No, that is not what he found
right,
in the context of section 10.3. That is my submission, and we'll go to the judgment in due course. But that is the key distinction, because what he found in the context of section 10.3 was not equivalent to a finding of misrepresentation.
right.
So if you take out, remove from the analysis the intention from the assessment of misrepresentation, then the overall balance tips in favour of the defendant. So on to ground one. And what I intend to do in terms of structure is first look at the ground of appeal itself, then address you briefly on the law of the damage element, thirdly take you to the relevant parts of the judgment and the unchallenged findings of fact, and lastly address EasyGroup's reliance on the fact that it is in the business of licensing its trademarks, and distinguish the authorities relied on by EasyGroup. So on the ground of appeal, I think I can deal with this quite quickly, because certainly it's become clearer in my mind what the ground is. And it is, as my learned friend said, a question of law. As a matter of law, do the facts that the judge found under section 10.3 support by themselves, without more, a finding of damage for the purposes of the passing off claim? So I understand it, it's as simple as that. So is the finding transferable? And it follows that what is not permissible under this ground is for my learned friend to ask you to make additional findings on this appeal that would support a finding of damage. Has to be all there in paragraphs 214 to 217, 218.
I don't think we are being asked to make additional findings.
And we say, crucially, on that, the judge has not made a finding that the ability of EasyGroup to charge others for a license would be diminished as a result of the defendant's uses of signs 2 and 3, which is the last sentence of paragraph 237, dealing with damage that we'll come on to. So we say the absence of that finding is crucial to the finding of no damage and precludes a finding of damage. So on the general law of damage, there's nothing between the two sides on the general principles that I discern. Professor Wadlow calls the requirement of damage the acid test for distinguishing an actionable misrepresentation from those outside the scope of the law. It is a freestanding test. It needs to be satisfied independently from the misrepresentation element. I add 3 comments to that. First of all, the likelihood of damage. The authorities talk about damage or the likelihood of damage. That, in my submission, is only relevant in a quia timit action, so I'm talking about likelihood of damage here, or if the misrepresentation is ongoing.
What was the second one? Or what?
Or if the misrepresentation is ongoing.
Yeah.
It's not historic. So in this, that's important, because in this case, the misrepresentations found by the judge, through the uses of signs 2 and 3, ended in March 2019 with a change to sign 4. So that was some 3.5 years before the trial and 6 months before the claim was issued. So the only question for the judge was, had damage in fact been caused? The second point to make on the law is that while in many cases a finding of damage follows from a finding of misrepresentation, that is not always the case. My learned friend took you to the Moroccan oil case where it was conceded, as it often is, that there is damage if there's misrepresentation. That's not always.
In passing off cases, findings of goodwill and misrepresentation but no damage were as rare as hen's teeth. The only one I could think of is 40 years ago in Stringfellows, and that's generally thought to be completely inconsistent with the modern approach to passing off.
Well, my lord, I was going to cite that case to you as an example of a case where...
Can you cite any more recent one?
That's the only one that's in the authorities bundle, the only one of which I'm aware. In my submission, there's not, certainly my learned friend has not said that there's anything wrong with that case in terms of the finding of
Hasn't addressed us at all.
it's an authority that he relies on, my lord. But in my submission, that shows that this is a genuine hurdle. It's a Court of Appeal authority.
Oh, to be sure, yes. I mean, of course, in principle, it is possible. But the point I'm putting to you is that as a matter of practicality, if you've got goodwill and you've got a misrepresentation which is relevant, then it's overwhelmingly likely, not inevitable, but overwhelmingly likely that damage will be sustained as a result. You can't assume it. You have to consider it and form a view on it, but the overwhelming likelihood is that damage will follow.
My lord, as I say, I concede that in many cases no separate argument is raised on damage if goodwill and misrepresentation are established. However, there are cases and the authorities are clear that it is a freestanding condition, freestanding element for it.
There's also a procedural problem with a split trial, isn't there? I mean, where you have a trial on liability only, what's the claimant supposed to be doing? You've got to prove some damage.
Some damage. I'd agree with that statement. Yeah, some damage. But that's important. They can't leave it over for the trial on quantum to establish. It needs to be established at the trial of liability because it is an essential element of the cause of action.
Yes, but the real difficulty is that because the claimant isn't obliged to bring forward any evidence as to quantum, the dividing line between deciding that there is some damage, even if it's completely unquantifiable, and saying that there's no damage is quite a fine line to draw.
Well, but they are required to bring evidence to court to establish damage, some damage.
Yes.
And we say they didn't do that for this case. So this is one of those cases, in addition to Stringfellow and McCain, where damage is not made out. There was one last point on the general law. So my learned friend relied on Urban and Talksport. And I can take my lords, my lady to that. So that's the Authorities Bundle A, tab 4, page 119. It's paragraph 38, which starts on 118, was the paragraph that my learned friend took you to. And this is clarifying what the modern law is. So in that sense, deals with my Lord Justice Arnold's point as to things moving on from Stringfellow. And the part that I point your attention to in particular is over the page on 119. The law will vindicate the claimant's exclusive right to the reputation or goodwill. It will not allow others to so use goodwill as to reduce, blur, or diminish its exclusivity. That, we say, is a correct statement of the modern law, insofar as it's moved on from Stringfellow and McCain. That is what is required to show damage. That the goodwill has been used so as to reduce, blur, or diminish its exclusivity. In this context, so in the extended cases that passing off now applies to. And we say the findings of the judge in this case are contrary to that. So they show that the exclusivity has not been reduced, blurred, or diminished. That follows from the finding.
Mr. Justice Laddie goes on to say that it's the misrepresentation which enables a defendant to make, use, or take advantage of the claimant's reputation. And if the exclusivity is diminished because of misrepresentation, then that is an invasion of the proprietary right, isn't it?
If it's diminished.
Yeah.
But it hasn't been in this case. There's a finding that it has not been in this case. Unchallenged finding that it hasn't been.
So just so I understand this, the first head of damage that was discussed earlier, which is effectively the lack of licensing income from these defendants, you say that, as I understand you, you say that's just not relevant to a passing off.
It's absolutely right. But for this reason, that argument is completely circular. Because all that says is that they're only allowed to do that if they pay a license for it. So that's what you pay for the permission to do that. And that's what actually Wadlow deals with that point. So that doesn't count as damage, because that would result in damage every time there's a misrepresentation. Because all that says is a trite statement of the affairs that you can remedy this misrepresentation by paying for it.
Yeah, but I mean, that debate has run through the case law in the context of negotiating damages. And is not the law in that context that you can claim a licence fee? Because what's being quantified is precisely the failure to ask for the licence.
But my lord, if that's right, then damage is not a freestanding element of the cause of action. Yeah. And it is.
Well, yeah, but then you get into this tension between the proprietary basis for it and damage being the gist of the action. I mean, I take your point, absolutely. The law tells us that damage is required for passing off. But how do you reconcile that with the basis for the action being the invasion of the property and the goodwill?
Well,
I'm not sure the law has quite got the answer to that yet.
It's Lord McNaughton's example of taking out the horse from the livery stable who's better for the exercise, isn't it? You still have to pay.
well, but that may be the difference between negotiating damages in a different context and passing on.
But it's use for somebody else's property. That's the point. And that's why you get so-called user damages in trespass to land cases. You use somebody else's property.
Yes, but what all that is being done here is using signs which call to mind the EasyJet mark.
Yeah.
That's what's been found. So I would stop short of saying that that's equivalent to that situation.
Right. Is that a convenient moment? 2 o'clock.